everyone. Good afternoon. Today is October 6, 2022. This is the Board on Professional Responsibility, and we are here to hear the matter of Pablo Zambora. It's board docket number 21 BD3 and disciplinary docket number 2017 D142. If the parties could introduce themselves for the record. I will start.
I'm sorry, Madam Chair. Miles Link for the Office of Disciplinary Council.
Thank you, Mr. Link.
And good afternoon. My name is Bruce Marcus, and I am here on Mr. Zambora's behalf.
Good afternoon, Mr. Marcus, and good afternoon, Mr. Zambora. I see that you're here as well.
Good afternoon.
So I will begin by noting that we will be deciding this matter with 8 members of the board as permitted under DC Bar Rule 11, Section 4D that defines a quorum as 6 members for deciding cases. I will also note what I think is probably obvious to everyone, which is that we're doing this hearing by Zoom. I know we're all very experienced at this point with that, but just a reminder, if everyone could put themselves with your mics off, if you could mute. And then only when the attorney is, at the podium arguing, can you turn your microphone on. The board members will also try to remain on mute, except when they're asking questions. And so I see we're good, Mr. Zambora. Can you put yourself on mute?
I am on. I think I'm on mute. Can you hear me?
I can hear you.
How about now?
Can still hear you.
Oh my goodness.
That's okay. Oh, perfect. Okay, thank you. So we are here today on exceptions to the hearing committee report filed by the Office of Disciplinary Council. And so, Mr. Link, you will begin. You get 20 minutes. Please let me know if you would like any rebuttal time, and then we'll follow with Mr. Marcus. So, Mr. Link.
Thank you, Madam Chair, and I'd like 5 minutes of my time for rebuttal.
Okay, thank you, and you may begin. The clock will get started.
Madam Chair, the office and members of the board, the Office of Disciplinary Council brought this action and filed specification of charges against Mr. Zamora for his multiple violations of a number of disciplinary rules, including 1.3, 1A and B, 1.4 A and B, 1.15 A, B, and E, 1.16 D, and 8.4 C. The hearing committee found violations of 1.3A, 1.15A, B, and E, and 1.16 D. The gravamen of this exception applies to respondents' violations of 1.15 E and his ignoring the requirements of in re mance. Although, again, it's in the context of multiple rule violations. And it's also in the context of the court's decision in re Adams, where a reckless or intentional misappropriation of client funds is subject to disbarment. And that's a per se disbarment. It's not subject to modification or waiver. And the hearing committee is bound by the court's decision in re Adams. And in this case, the hearing committee majority refused to follow that requirement. The chair of the hearing committee posted a dissent, which is very eloquent and very persuasive as to why disbarment is the appropriate sanction in this case. Mr. Zamora was admitted to the bar.
Mr. Link, is it ODC's position that respondents' unawareness of Mance is itself reckless?
That is part of our position, yes. Respondent was admitted to the bar in 2011, January 2011, 2 years after Mance was decided. The court has never held that an attorney admitted after Mance was decided could be found to have simple negligent misappropriation. Distinguished where attorneys are admitted prior to Mance, they have often argued that they tried to comply with Mance, but they had a prior practice of accepting advance fees as their own, and the court has sometimes held, depending on the circumstances of a case, that might be negligent. Here, there is
If I can
no-
interrupt for just a minute, if it is ODC's position that the unawareness of Mance is itself reckless, how do you square that with HAR 3, in which the court said that it could not say that inattention to updates in the field of legal ethics automatically renders a person consciously indifferent?
Because it's inattention to updates in legal ethics. Mr. Haar was admitted in the 1980s, and his argument was, I have tried to comply, but I have been inattentive, if you will, to updates. Mr. Zamora was admitted after Mance. There's no update for him to argue. He has to comply with the rule as existed. And note, by the way, his fee agreement referred to 1.15D. That provision in Rule 1.15 had been changed in 2010, a year before he was admitted, to 1.15E. So in his own fee agreement, he didn't reflect the accurate and current rule that he was supposed to apply. So when he testified at the hearing, he was asked the following question: do you have to notify the client about any risks or consequences of not putting their money in a trust account? The only accurate answer to that question after 2009 is yes. His answer was, I'm not entirely sure if I understand Rule 1.15E, he said, to say that exactly. That is reckless disregard of the welfare of his clients.
Now, in HAR 3, the respondent became aware of Mance, yet he still failed to bring one of his cases into compliance. The court, though, found HAR only negligent, not reckless. So how then can the conduct of the respondent here, when he wasn't even aware of Mance, rise to the level of conscious indifference?
Because he should have been aware of Mance. If this board does what the majority of the hearing committee did and say that a lawyer admitted to the bar after Mance was decided can nonetheless say my ignorance of Mance is simple negligence, as the chair of the hearing committee said, you will open the door to using that as an excuse by every lawyer who doesn't want to comply with Mance. The issue this board has to deal with is that it's not that Mance is unclear or people don't, it's some lawyers simply don't want to comply with it. And it cannot be said that a lawyer admitted after Mance was decided can absolve himself of responsibility by saying, well, I was unaware of Mance. No, you could not say that for any other area of the law, and you should not be able to say it here, and the court has never held it. We noted in our brief a number of cases where the court has found negligent misappropriation, and in each of those cases, it's where the attorney had been admitted prior to Mance, and their argument was, we tried to comply with Mance, and we just weren't successful. Here, the attorney doesn't even say, I tried to comply with Mance. He says, I was unaware of Mance. I was unfamiliar with Mance. That is reckless disregard. The whole point of Mance was to protect clients when advance fees were provided. If we say that you can say, after Mance was decided, I was unaware of Mance, after the bar had numerous CLE programs, after the DC Bar's professional assistance program assists lawyers with compliance, if you can say that I was simply unaware of Mance after 2009 and he was admitted in 2011.
Mr. Link, can I interrupt you? I have a question about In Re Pons. That was decided a little bit more recently, and I appreciate the parties having some supplemental briefing on that. But when I look at Pons, it says that to satisfy the requirement in connection with a flat fee, there's 5 things that have to be done. And I'm going to read through the list and ask you what was missing here. 1, the attorney will treat the advance fee as the attorney's property upon receipt. That's what happened here, right?
Right.
That the attorney can, 2, the attorney can keep the fee only by providing a benefit or providing a service for which the client has contracted. That was in the fee agreement, right?
Right.
Okay. 3, the fee agreement must spell out the terms of the benefit. That was in the fee agreement as I read it. 4, the client must be aware of the attorney's obligation to refund any of the advance fee to the extent that they were unreasonable or unearned if the representation is terminated. So that was in the fee agreement. Is that right?
I don't think that was. I don't think that was to the full extent that Mance was required.
There's certainly reference to the fact that if the representation ends early, that unearned fees would be returned, if I recall. Maybe not
Right,
exactly
right. No.
phrased as you would like.
Right.
5, unless there's an agreement otherwise, the attorney must hold the flat fee in escrow until it's earned. And here the fee agreement says that it would not be held in trust. So
Right.
based upon those 5 things in Pons, what was missing? What was
missing is the requirement in Mance, which the court in Pons also found had not been provided, was that the attorney must advise the client of the risks associated with not putting advanced fees in trust. That is, there is a risk those advance fees, if they're taken upon receipt as the attorney's own, may not be available to be returned or may not be returned. And in fact, in this case, all of the advance fees that had not been earned were not returned to the client in this case. So the requirement in Mance that the attorney must get the client's informed consent to the fee agreement. In Pons, the court held informed consent was not obtained, and here informed consent was not obtained. In fact, even the hearing committee, the majority of which went out of their way to read every bit of evidence in favor of respondent, even that majority said, and I quote from Finding of Fact 59, "It is not fully credible that respondent went through the 2 agreements with Ms. Stiles with the detail necessary to obtain informed consent to place client funds outside of a trust account. It is not fully credible." That means it's not believable. That means even this majority that went out of their way to give every benefit of the doubt to Mr. Zamora said this didn't happen. And that's the additional requirement of Mance, which was not in the fee agreement and which he did not explain to the Ms. Stiles.
And there's a full site, and there's a site that you can point me to in Pons that reiterates, and it's not just these 5 things that I listed.
I think we went over that in our brief, in our supplemental brief, and I refer you to it.
Okay.
Mr. Link, how does the record in this matter, or lack of record, as to the respondent informing his client or the client's wife as to reasonably available alternatives factor in here? Is that all part of the Mance mix, or is that a separate consideration when determining whether informed consent was attained here?
Mr. Walker, that is part of the Mance mix and determining whether informed consent was obtained. Obviously, the alternative, well, certainly one alternative, is to place the advance fees in a trust account and explain to the client the benefits of that, and simply explain to the client what that means. For some unsophisticated clients, the whole notion of placing funds in escrow needs some explanation. And by definition, the clients involved in this practice were unsophisticated clients for whom, I would remind the board with respect, Mance was designed to protect. They were not Ms. Stiles, who was acting on behalf of Mr. Asensio. The client did not get that information. Whatever consent she gave to the agreement, which she did sign, was not informed. And that's why this case is like Pons. In Pons, the court found there was no informed consent, and therefore the court found that disbarment was required.
Mr. Link, if respondent, being unaware of Mance, had nevertheless explained to Ms. Stiles the risks generally of a flat fee not being held in trust, and discussed with her the alternative fee arrangements available, but didn't provide the 5 enumerated pieces of information in Mance, would that still be recklessness?
Madam Board Member, that's an interesting question. And I think we'd have to look at that case carefully. That's sort of like saying, suppose a respondent provides a client with all of the required disclosures that Mance requires, and even though the respondent may not have known about Mance, but let's suppose the respondent, out of his or her own sense of responsibility, provided all of the Mance disclosures without referencing Mance. Well, that would be fine. But what Mance did was
my hypothetical is slightly different. It's that there was no communication of the 5 enumerated pieces of information in Mance, but yet there was an explanation of the general risks of a flat fee not being held in trust and a discussion of alternative fee arrangements, but just not the specificity of the 5 pieces in Mance. And my question is, in that hypothetical, would your position be that that's still recklessness?
We would have to see the actual language, because you're saying the attorney did not provide the Mance required disclosures, but provided other disclosures that may have been analogous to or similar to Mance. And we would obviously want to see what were those disclosures exactly, and how close were they. And again, my earlier point was, to the extent the disclosures end up being synonymous with the Mance disclosures, well, then no harm, no foul. But to the extent those disclosures are not, and they are something less than what Mance requires, there would be a problem.
Thank you.
Thank you. And thank you, members of the board.
Thank you, Mr. Link. Mr. Marcus, you have 20 minutes and you may begin at any time.
Thank you very much, Madam Chair. Good afternoon. It is apparent to me that the panel is well versed in what the issues in this case are. Respectfully, it appears to us that there is a single issue in this case that relates to the question of whether or not Mr. Zamora could be found to have been reckless, assuming that there was evidence to support that, as distinct from negligent. And as the panel has obviously articulated, in simplest terms, what this case is at this particular moment is one where there was deemed to be a failure of proof. The panel in the dialogue that's going back and forth has sort of zeroed in on what we think the circumstances of this case are, and it turns on issues that relate to informed consent. And as I listened to the discussion during Mr. Link's comments, it became clear to me that informed consent is not something that is unique to lawyers. Informed consent is something that is discussed in the annals of DC law and federal law, having to do with what level of consent is there and what level of responsibility would, in the case of a professional, whether it's a physician or anybody else, in order to demonstrate informed consent. And in this case, what we basically have is informed consent that would have come in one of 2 forms. The first of which would have been in written form, and to the extent that there were discussions orally. And to suggest that a failure of informed consent, if that is in fact the issue, constitutes reckless behavior, I think we wind up turning the definition of informed consent literally on its head.
Mr. Marcus, but isn't misappropriation by definition unauthorized use? And the only way to obtain authorized use is through informed consent? So I'm not sure I understand the distinction you're drawing.
So under the definition that has been applied, and let me say, disciplinary counsel will be part of my comments. I do not direct my comments and criticisms necessarily to the positions taken at Mr. Link, but rather to disciplinary counsel as essentially the party opponent for purposes of these proceedings. The distinction between misappropriation under the law is that there are 2 varieties. One, would be where the misappropriation was accomplished by either reckless means or with some sort of intentionality. The distinction between those two categories and misappropriation, which occurs absent that higher level of intentionality or gross reckless disregard, if you will, with the interests of the client, leaves us with negligent misrepresentation. And the distinction is that not every failure to provide full information constitutes recklessness or an intentional avoidance of whatever obligations the professional, in this case, Mr. Zamora, would have had. The panel has inquired, and one of the first things that comes up in this case is that there were written agreements, engagement agreements, and those written engagement agreements were quite clear in that they contained a number of pieces of information. And the panel
Marcus,
obviously.
can I interrupt you? Because we're familiar with the retainer agreement, and I think we agree that there's a number of things that are in there. But one of the things that I think that is missing is what Rule 1.0E, which is the definition of informed consent, that it's missing. Now, it doesn't have to necessarily be in writing, I don't think. Maybe someone will correct me if I'm wrong on that, and I'll certainly look into it. But I don't know that it has to be in writing. But I do think that the record does reflect that material risks and a reasonable alternative of available alternatives were not discussed with the client. And if they were not discussed, and that is what is required in order to get informed consent, does that mean that conformed consent was not obtained here?
We are not arguing or taking exception to the fact that the finding was informed consent. As the panel knows, we did not take exception to the analysis, and we did not take exception to the fact that there was a determination that informed consent had not been given.
So then that raises the question of what it does seem to be the defense here, which is that this lack of knowledge of Mance. And I'm struck by the question of why does knowledge of Mance, why is that necessary to ensure that material risk and reasonable alternatives, available alternatives are discussed?
Insofar as a policy reason, why?
No, I'm just saying as a lawyer, why is lack of knowledge of Mance why is that sort of a defense to not getting informed consent here?
What we are saying is that it is not a defense to informed consent. What we are saying is that you have to go to the next level, because as we know, if the misconduct takes place, that one of the inquiries that must be undertaken is what was it that prompted the lawyer's failure to provide informed consent in a manner that strictly complied with Mance. And so in this case, if there is a failure, and we have not taken exception to that, and we have not taken a position contrary to what the majority opinion was as to whether or not there was informed consent. Otherwise, we would have been arguing that there was no misappropriation.
Okay, so that's fair. I mischaracterized the argument that this is more of a question of it's negligent rather than reckless because of a lack of knowledge of Mance. And I'm just wondering, do you need a knowledge of Mance if you have a knowledge of the rules? And here, where it is clearly defined.
So in this case, as to what informed consent was, whether Mr. Zamora understood the full panoply of things that he was supposed to explain and what he needed to do in order to provide that information to the client, his failure to do so, whether it was a failure to understand the rule, whether it was a failure to understand the holding in Mance, whether it was a more basic failure, which is to provide information to a client such that the client could make an informed decision as to what to do. Whichever of those scenarios that the board finds to be lacking here, and very well could have been all of them, the question is whether his failure to do that rises to the level of recklessness.
And that raises my question, Mr. Marcus. The testimony of the respondent was that he didn't think there were material risks to convey. And how is it objectively reasonable to believe that there were no material risks to convey to the client about the flat fee arrangement if the respondent also understood that he needed a waiver from the client of the requirement that the flat fee be held in trust? I guess, in other words, why would you need a waiver if there is no risk or no material risk?
So I guess the issue here is that if you take a look at this agreement where he was aware that he required a waiver, as to whether or not that waiver was the functional equivalent of him providing a full description of all the potential risks that are described in the cases and in the definition of informed consent, he didn't do that. But that doesn't make it reckless. In fact, to the contrary, what winds up happening here, if you take a look at this, it's a miss, it's negligence, but it is not reckless. And as the board found, and even with the dissent, there was no issue that was taken as to intentionality, which obviously introduced the specter of some kind of scienter or fraudulent.
Mr. Marcus, you're asserting that it wasn't reckless and that it was just negligent, but I'm not sure you're explaining how it was just negligent. So did your client know about the terms of Rule 1.0?
It does not, the record does not reflect that. But on the other hand,
should he not have known about it? Isn't it objectively reasonable that he should have known about the terms of Rule 1.0, regardless of Mance?
If he should have known about it, then obviously he would have understood what informed consent was.
But are you saying that there was no, that maybe he should not have known about it, or that, I mean, should he not have known about Rule 1.0 is what I'm asking.
I think it is implicit that lawyers are responsible for knowing rules. They're responsible for knowing case law. They're responsible for knowing.
So if he should have known about Rule 1.0, the terms of which it's like a sentence law, got a couple of clauses to it, material risks, reasonably available alternatives. Isn't it, if he knew the rule and he knew the terms, how is it objectively reasonable if, for example, as the record I think indicates, he did not discuss in any way reasonably available alternatives with his client?
So
that's a very compound question, but how do you get to objective, subjective belief there? Didn't he have understood the simple terms of that rule?
And Mr. Walker, what I would say to you, sir, is this. Let's suppose he says, you know what, I didn't know about that rule. Or I didn't think about that rule. Or I didn't understand that rule had applicability to the circumstances given what I had written down. And let's assume that's all true. Unless there was something more, unless there is an additional ingredient that elevates that negligent behavior to something which is of a quality equal to recklessness, then his actions are negligent.
Do you not think that it's reckless for an attorney practicing in DC and who repeatedly engages in these kinds of fee arrangements, the ones that are at issue here? Do you not think it's reckless for an attorney in that position to fail to understand the Rule 1.0? Are you saying that that's simple negligence if he didn't know the rule or understand it?
I do not think that is reckless. I think it's negligent. And I think it's negligent for these reasons. If the lawyer did not know it, in every case where a lawyer does not know a statute or some kind of rule or regulation, if that in every instance where the lawyer was supposed to know it and didn't know it yields a result that it's reckless, then obviously we have a per se standard that does not allow for what the court has repeatedly said is understandable to be negligence.
Of course, I'm not talking about every instance here. I'm talking about this instance of a practitioner in this field who engages in this kind of an agreement repeatedly, routinely, as a matter of his practice. not talking about every instance, so please don't distract from the argument. This attorney, in these circumstances, was it not reckless for him to simply ignore the terms of Rule 1.0?
I depart with you, Mr. Walker, on the question of whether he ignores it. There's a difference between conscious disregard for an obligation, and the court has determined that the definition of reckless is essentially conscious disregard for an obligation.
Mr. Marcus, following up on Mr. Walker's question, said another way, is it your argument that Mr. Zamora is not acting recklessly when he fails to read the rules of professional conduct, understand them, and apply them to his practice? Are you saying that it's not a reckless behavior for a lawyer?
I think that what you have to do, Ms. Cassidy, is you have to take a look at the entirety of what went on in order to put yourself in a position to determine whether or not Mr. Zamora was reckless in the totality of the circumstance. If you sit there and you parse out one thing and say, okay, he didn't do this, so therefore he is reckless. I think what you need to do.
I following up on that, I don't disagree with you, but Mr. Walker's point is this: if we look at the totality of the circumstances and look at what the rule of informed consent requires, first off, Mr. Zamora's practice involved individuals who were unsophisticated in understanding these types of agreements. Number two, he seemed to operate in a flat fee world where he was seeking a waiver of what is the accepted practice that the flat fee enters the IOLTA account. When you look at these factors, as you're saying, it seems to me that the non-reckless lawyer would have become well familiar with the informed consent requirements and executed on those in their interactions with their clients. So I think Mr. Walker's question is, given the factors in this case, it seems like Mr. Zamora did act recklessly for failing to consider these factors. Are there other factors that that thought process?
Well, I think if the board takes a look at the totality of his agreement, and you take a look at all of the things that were contained in this. So, the question is 80% or 90% close enough? Does that indicate that there was not a complete abject repudiation of what the obligations are? And I think if you take a look at this, there were pains that were taken that Mr. Zamora went to in this agreement. And you can compare this agreement to either what was said in Har, you can compare it to Pons.
Mr. Marcus, if I can interrupt, I'm glad you took us back to the agreement, because the comment to Rule 1.15D specifically refers to informed consent being defined in Rule 1.0E. And Mr. Zamora's fee agreement specifically cited Rule 1.15. So even if the respondent was not aware of Mance, why doesn't the record evidence here and the citation to Rule 1.15 in the fee agreement itself evidence a conscious indifference to the comment of that rule and the longstanding requirements of informed consent?
Because in order for you to have a reckless disregard, you basically have to say, I don't really care. I mean, it is wanton. It is not the norm in just simply abandoning your responsibility.
Mr. Marcus, if I may, isn't it a wanton disregard to?
That's a supportable inference.
If the panel believes that, if this board believes that his failure to know and understand the issue of informed consent, if that is to be construed in this case, because one of the things that, and I didn't get to this with Mr. Walker, is we were not asked questions about other cases where there were discussions. We do not have before you today any issues about what kind of information was conveyed and with any other client, and to assume that whatever discussions took place or whatever information was in another case obviously is outside the record, and it assumes things that obviously are not contained in this case by allegation or otherwise. So,
Mr. Marcus, I think just to bring that point that you just made back, I think at least my point is that this Mr. Zamora's client, Ms. Stiles, and her husband in this matter are in fact unsophisticated buyers of legal services. And my question is it not reckless for a lawyer to put in what he has at the very end of his agreement, which is simply what appears to be a citation to a rule of professional conduct without greater context for his client to get informed consent, which is defined in our rules, which is the lawyer gaining an understanding that their client understands what in fact is being conveyed to that client.
So the issue about the citation to 1.15D, I think, was made clear during the course of the hearing that it should have been 1.15E. So to the extent that it was 1.15D, I think it was, and the questions that were put during the course of the testimony, my recollection is that there was an acknowledgement it should have been 1.15E. So, and obviously the issue of informed consent doesn't really turn on whether it's D or whether it's A. The issue of informed consent. I'm sorry.
Go ahead.
Oh, yeah.
I was just going to ask Mr. Marcus, are you able to point the board to the best case or two that you would cite to support that the conduct here is negligent rather than reckless?
Oh, I think you can take a look at Mr. Haar's case. I think you take a look at Mr. Pons's case, because in Mr. Pons's case, the court went through an analysis of what Mr. Pons did. And in Mr. Pons's case, the issue there was not simply limited to whatever discussions or lack of discussions. In Mr. Pons's case, what the court saw there was sort of, and I'm going to go so far as to say gross inequities in the relationship between the client and the lawyer. And the agreement that was entered into in Pons did not call for such things as repayment of any amounts that had been unearned. It called for a fixed fee that was later changed after the money was paid, and there was a refusal to remit the money, even though the money had been obtained prior to the charges being filed. And so there were a whole series of things in Pons, and the court under those facts did not say that there was not negligent misappropriation, and did not walk away from the notion that it is incumbent upon bar counsel to get into essentially the mind of the lawyer to figure out whether or not the claimed misconduct was the result of recklessness or intentionality. And I think that one of the things that charged in this case was intentionality or recklessness, and the majority of the panel, and not disagreed with by the dissent, was that intentionality was not part of this. So the only question here is, if you agree that there wasn't any intentionality, if you agree that this was not done to benefit Mr. Zamora, that this was somehow or other used for either chicanery or trickery or some form of deceit, if you believe that, then the question is, what was it that he did? And to the extent that he was not familiar with the rule, to the extent that he was not familiar with the holding advance, he was candid about it. The panel found that he was candid about it, and they found that his negligence in not being familiar with these things would lead to the conclusion, not that he shouldn't be held accountable for misappropriation. That is not what they found. What they did find is that you had to go further and look to see whether or not the proof in the case, by clear and convincing evidence, demonstrated a reckless disregard for the interests of the client. And that finding simply was not made. Now, I realize my time is up. I would say one thing to the panel. I commend to you the conclusions, even in the dissent, as to the outcome in this case, And the outcome in this case, once you take a look at Mr. Schwartz's comments as to what the perceived sanction would be, there's no doubt that given what this conduct was over what apparently is a $750 dispute, that, and I'm not saying that the amount of the dispute necessarily guides what should be done either at the board or later on at the court, but this is an extremely harsh result for an attorney who has had no disciplinary history, has practiced immigration law exclusively out in California, and would not have been in a position to have availed himself of all of the programming and things of that nature that may have been available for a lawyer that's here. I'm not saying that he didn't have that obligation, and I'm not suggesting in any way that that by practicing in another locale that you're absolved from responsibility. I am saying it to put into the context of what is understood in this case, I believe, to be negligent as opposed to a higher level of intentionality or disregard. I thank you very much for allowing me this additional time and appreciate your attention. Thank you.
Thank you, Mr. Marcus. Mr. Link, I believe you have 5 minutes.
Thank you. If, in addition to not being aware of Mance, the respondent's position is now he was not aware of Rule 1.0E and his obligation of informed consent, then we would say, yes, that is absolutely per se reckless misconduct for a lawyer not to be aware of that. And I would quote to you the language from the dissent. Whatever laxity in compliance may be explained by the uncertain grasp of Mance cannot excuse the failure to comply with such a significant safeguard of a lawyer's clients as the concept of informed consent without gutting the rules altogether. If we now allow a lawyer to say, I'm not familiar with the concept of informed consent and therefore do not have to obtain informed consent from my clients, we are, in the language of the dissent, gutting the rules altogether. I would also refer the board to the court's decision in Re Wendell Robinson. That's at 583 A. 2nd 691. And remember, in this case, the only mitigating factor introduced by the respondent was his ignorance of the law. In that case, and the amount at issue, my learned colleague indicated was $750. In Wendell Robinson, the amount at issue was $400. And listen to what the court concluded in that case. The mitigating factors in this case, the relatively small amount of money, the relatively short period of time during which the client was denied the misappropriated funds, the absence of financial harm to the client, neither of those two factors are present here, by the way. The fact that the misappropriation involved a single client, that's an issue my learned friend raised. The relative inexperience of respondent, the absence of a prior disciplinary record, the hearing committee took that into great account, and the character testimony offered on respondent's behalf, that was not present here. None of those factors, the court said, these factors are insufficient to overcome the presumption of disbarment. Remember, this case, as in all disciplinary cases, is not about punishing the respondent.
I have a real quick clarification. Did I understand you correctly that you said in Ray Robinson was also about ignorance of the law, or did I mishear you?
No, I did not say it was about ignorance of the law. It was about, it was a misappropriation case, and it was about a reckless misappropriation.
Okay.
Again, there were multiple issues in that case. I just wanted to point out that the amount at issue was small, and that's not the issue. In Ray Adams does not create that as an exception. And it's if the court wants to create that as an exception, the court can do that. It's this board's responsibility with respect, and it was the hearing committee's responsibility with respect to follow the law. The majority of the hearing committee attempted to rewrite the law. We urge this board not to do so. The dissent is eloquent, and we think it clearly lays out, as we also tried to do in our briefs, what the issues are in this case. The bar needs to understand that you've got to comply with these rules and you've got to comply with the law. And for an attorney admitted after Mance was decided to say, I'm unfamiliar with Mance, for any attorney to say, I don't understand the concept of informed consent, this board cannot allow that to go. That is reckless disregard for the welfare of your client. And the only appropriate sanction for misappropriation like that is disbarment. Thank you, Madam Chair and members of the board.
Thank you, Mr. Link. Thank you, Mr. Marcus, for both arguments this afternoon. Your case is submitted and